Or some form of questions we get on our Twitter handle there. Let's just hope that our next guest will be able to put an answer to all of that. Just in case you might be looking for your bank, well, if you were with Bank PHB, is now Keystone Bank Limited. So just look out for it so that you don't get to miss out on that. And of course, if you were with AfriBank, is now Main Street Bank Limited. And those of you who were with Spring Bank is now Enterprise Bank Limited. Joining us to look at all of that and see how we can really forge ahead this morning as someone who's been an industry watcher in terms of the financial market is a legal practitioner, Mr. Ikeji, a lawyer.
Thank you so much for having me live.
Well, let's first of all start with a deadline given to these banks and the implication of all of this in the law court. They say it was September 30th.
Yes.
And all of that magical stuff happened over the weekend, as well as the appointments of these managing directors as well as chairmen. Specifically, it happened on a Sunday. What's the implication of all of that?
Well, the implication of the September 30th deadline is just that that deadline is a regulatory deadline. But there is a law backing that regulation. And like I have said several occasions here, the law is usually above regulations. So when a regulation is in conflict with a law would supersede. The law is clear there. Section 38 sub 1 and section 39 sub 1 2 of the NDIC Act. Both sections have given both the NDIC and the CBN powers to do what they have done. Section 38 specifically empowers NDIC in association with the CBN to take over failing banks. The operative word there being failing banks, not failed banks. So
they mustn't wait for it to collapse.
Failed. It's failing banks. So if in the opinion of CBN and NDIC, these banks are failing and there will be need to intervene, the law is there to protect their action. The fact of September 30th deadline, of course, we should ask questions. Why not wait for the deadline you've put out to the public and our minds are waiting for? Why take us by surprise? Those are two extremes, the moral angle and the legal angle. From the legal angle, it's the CBN action is well taken. But from the moral angle, you start asking questions. Why didn't you allow these people enough time to...
But just before this move, the shareholders of some of these banks had taken the CBN to court. Yes. Now, what do you think the CBN considered legal action from shareholders before making this move? Because one of the CBN directors actually said, we hope that there will be no legal challenges from the shareholders.
That's a possible desire, so to speak, from the CBN director. This action must be subject and should be appropriately subject to legal actions. We need to test.
Why if there's a law backing the action, why still go to court to challenge that law?
But you remember, there is law, there is constitution. The constitution is law at the apex of all of these laws. If any of these laws, you come under any of these laws and act in such a way as to breach, or there's a likelihood of your breaching the provision of the Constitution, then those affected are better served going to court to ask the courts to intervene or for redress, as the case may be. So CBN taking that action should, at the back of their minds, expect cases in courts, especially given the fact that there were still cases pending. Now, it raises questions of whether the action of the CBN and NDIC presently is not sub judice. Sub judice in the sense of impugning the sanctity of the judicial process, whereby there is a case or there are cases pending on some of the previous actions of the CBN, part of the process of which has culminated to the present takeover. And the CBN still goes ahead to still take over. you know, whereas there are actions questioning their earlier actions, you know, that form part of the process of the takeover.
You know, Mr. Ikeji, if you look at the role of the NDIC and the role of AMCON, when AMCON was created, they said it was created to soak up toxic assets. That was its role. And it seems that this is the first time that we're seeing NDIC set up breach banks. Some people will argue that it means that at some point, possibly what all these banks needed was someone to, you know, soak up their toxic assets, give them another lifeline, and, you know, possibly, you know, give them another life, another breath of life, so to speak,
yes.
that they were still viable, sort of. You know,
yes.
We've never seen the NDIC set up a breach bank. Usually we see them liquidate and ensure that depositors get their funds back.
Yes.
This is the first time,
yes,
isn't
this is
it?
the first time. I think they are trying to exercise their powers under the law. Under the NDIC Act, Section 39 empowers them to set up breach banks. Banks that will act as bridges, you know, as link process between the takeover or between the intervention and the eventual ownership, final ownership of the banks. So the NDIC, having not done so previously, is without prejudice to their power and their powers to so do. We may wish to ask one question here. If you are setting up breach banks and you are doing so to protect depositors' funds, as it were, what happens to the investors? What happens to the foreign investments that we expect? What is the picture? What signal are you passing out in setting up these breach banks? You know, so with the breach banks are not in themselves bad idea, but you may ask questions as to the appropriateness.
Well, the bridge banks,
you know,
no longer exist. That's what they say, that AMCON has finally bought over the bridge banks and they have ceased to exist. So Keystone, Mainstream and Enterprise banks are now banks in their own right. And they
no, I don't think so. I don't think so, legally speaking.
That's what they say. I mean, that's I'm quoting from them right now.
Yes, if you look at the definition of breach banks, legally speaking, you would understand that breach banks are banks that are in themselves not the final product, not the final situation, not the final process, but a linking process to the final process. And if you look at their announcement, they say that those banks can still be subject to investments within the next 2-3 years. So Keystone Bank, Main Street Bank, and the third Enterprise Bank are still subject to further investment.
Yeah,
from
subject
investors.
to further investment, but
Yes.
taking this quote here, I don't mean to, stress this issue, but it says, Mr. Chiedu K. Morgalu stressed that the new banks are no longer breach banks as at today, that's Saturday.
Yes.
They were breach banks as at yesterday, Friday, which means that they now exist.
As at today,
That was on Saturday when they were bought over, when the NDIC transferred those banks to AMCON and AMCON took over the shares of those banks. It means that they're no longer breach banks. They're now fully owned by AMCON, and AMCON has pumped in money. 679 billion is how much they said they're going to pump into those banks to give them life again, and then wait till investors come and buy them over from them.
I think it's a matter of nomenclature. It's a matter of semantics, the language used. Morgalu may have said that in the understanding of CBN, these banks are no longer breach banks. But you look at the intention, the effect of the action. The effect of the action shows that these banks are not, the Keystone banks presently as owned by
Banpage.
as owned by government,
yes.
by AMCON,
AMCON.
presently as owned by AMCON. They are not the end owners. This process is a process. I want you to understand the principle. This process is a process of creating stability in the system, so that good investors, at the appropriate time, good investors will come in and take over.